Minister, this question just relates to successful tenders for public contracts from outside the jurisdiction and what proof they have to show to the awarding body that they're in compliance with taxation law and employment law to ensure that they're not using any workers who are operating in the black economy.
Thank you. Minister.
Well, this again overlaps the question that I've answered earlier. Public procurement procedures require all applicants to meet standards when applying for public contracts. In this regard, applicants are required to make declarations in relation to the financial standing, their legal standing, and in relation to payment of taxes and social contributions. The criteria upon which contracting authorities may exclude applicants from the awarded procedure of public contracts are set out in a public procurement regulation and in directives. Before the applicant is excluded, an applicant, as I've said, can make obviously a case in mitigation, and that must be considered by the contracting authority. It is a condition of awards of public contracts above €10,000 that a successful applicant provides to a contracting authority either a current tax clearance certificate or demonstrate a satisfactory level of subcontractor tax compliance in the case of a construction, forestry or meat processing sector. They're subject, as I've said previously, to the relevant contracts tax. The same tax clearance requirement applies to all non-resident contractors being awarded a public contract. The management of the tendering process for a public contract is a matter for each contracting authority. It is the responsibility of each contracting authority to ensure that tenders comply with all the requirements of the process.
Deputy Pringle.
Thanks, Minister. That's required in the application process or the tendering process that they're required to show these proofs. But what actual steps are available to bodies when the actual contractor, after he's been appointed, and monitoring while the work is ongoing, and particularly in relation to subcontracting of elements of the contract as well, because I do believe that there is a certain amount of a blind eye turned to this, because the awarding of contracts is generally on the most competitive price, and because the costs of doing business are less outside this jurisdiction, it's very difficult for tenders, companies resident here to actually be successful on price alone. And I'm just wondering if you could expand a wee bit on what actually role the public body can play after the tender has been awarded and while construction is ongoing to police this measure, and really that I believe that does need to be stepped up.
Thank you. Minister.
As I indicated earlier to Deputy Fleming, it is the legal responsibility of the contracting authority. If it's a school, the Department of Education. If it's a road, the Department of Transport and the NRA, to ensure that all legal requirements are complied with. Now, you raised the case of subcontractors. Subcontractors in any public sector contract, if they have a contract greater than €10,000 inclusive of VAT, which is not a huge contract, clearly, it will be a condition of the award of the main contract that all subcontractors employed on the projects must produce a tax reference number where a payment exceeds €650. Records of tax reference numbers must be kept by the contractor, must be available for inspection by the Revenue Commissioners. Where payments exceed €2,600 in any 12-month period, the subcontractor is required to produce a current tax clearance certificate. Payments under a contract are at all times conditional on compliance with all the set out contract requirements. The management, as I've said, of the tendering process is a matter for each contracting body. If the deputy, and you've again instanced your concerns about some contracts, if you have concerns about the non-compliance with normal legal requirements by any contract awarded in the state, I'd be obliged to hear from you, and I'll ensure that it's investigated.
Deputy Pringle.
Thanks, Minister. Well, I'm generally concerned about how it's actually policed and how it's actually enforced. Like for many years, contractors had to be compliant with the construction industry pension scheme, and local authorities particularly, I don't know about the national bodies out there, they turned a blind eye to it completely because they were getting them on the most competitive price. And then when it was actually, I raised this with Donegal County Council a number of years ago, and when they started forcing contractors to comply, basically what they did was they registered one employee and got a letter of compliance from the Construction Industry Federation saying that they were part of the pension scheme, and that got over the difficulty for them. So, I mean, it's an ongoing problem, and it's a problem that does need to be looked at. For example, if as an authority is aware of a contractor or has had difficulty with a contractor in the past in compliance, is that enough for them to exclude them from future contracts? Could they adopt that role or adopt that position, and would it be defendable, basically?
Thank you. Minister.
Well, you've raised a number of questions. Your last one first. There are set criteria for excluding somebody from the tendering process, but obviously, fair procedure has to apply, because it's a significant penalty to exclude somebody from being able to apply for a public contract, and they would have recourse to the courts to vindicate their rights to do that. But I can forward the deputy the criteria for disallowing a contractor from applying. I have established in the last 2 years, as you know, the Office of Government Procurement, because there was a lot of ad hocery about the way general procurement happened in the public service. We've now a much clearer procurement mechanism, a much more transparent procurement mechanism, and it might be useful, I don't know which committee the deputy is a member of, but if you're a member of a committee that deals with procurement generally, to have the new government procurement officer explain the procedures and maybe ask in terms of anything that needs to be tightened, either in the contract documentation or in the contract monitoring that might be of use.